So, ladies and gentlemen, on Zoom, welcome to the book talk organized by CCPL, the Center for Comparative and Public Law. My name is Fu Hualin. I'm the Dean of the Faculty of Law at the University of Hong Kong. Today, we are delighted to have our old friend, Professor Pitman Porter, to introduce his new book. The title of the book is Exporting Virtues. There's a question mark. Pitman is one of the older generation of China law scholarship in the English world. I may look pretty old now, but then I sort of grew up reading Pitman's writing, and he has written so much and so many important works. One of the book which I still recommend a student to read and read carefully is his 2003 book, From Leninist Discipline to Socialist Legalism. And his article on Riding the Tiger is particularly meaningful at this particular moment. So for those who haven't looked at the earlier writings, I strongly recommend you that we go back to the library and start to read again. So Pitman is a professor emeritus at the UBC Law School, and he will present his book in about 20 minutes, and then followed by discussion, comments by two of my colleagues, Jed Krank and Insha. So without further ado, may I ask Pitman to start your presentation. Thank you.
Well, excuse me, thank you very much, and greetings to all. I'd like to begin by thanking Dean Fu Hualing and Hong Kong University Law faculty friends and colleagues for their ongoing support and friendship over the years, and in connection with today's talk in particular, also Yingxia and Winnie Law, and also Jed, who is Kronk, who is going to be a discussant. So thanks to all of you. What the book is really driven by, as noted in the introduction, is China's increased international activism in the period of Xi Jinping. Now, this started, of course, before or had been going on for some time. So, for example, Hu Jintao's speech to the 18th National CPC Congress in 2012 talked about increasing exchanges and cooperation and promoted reform and global governance and securing more representation and so on. So clearly China's international activism had been going on for some time, but I think Xi Jinping's speech to the 19th Party Congress in October 2017, where he championed the development of a community of shared interests and encouraged the evolution of global governance, and particularly the rise in China's international influence, ability to inspire and power to shape. So, I think all of this is a context for this process, and I think what we're seeing is China transitioning along with its other very many levels of influence from being a norm taker to being a norm shaper, and human rights is an example of that work. So one of the things I'd like to do is just to touch briefly on the implications of all this and why it's important. I mean, it's important that human rights be identified as an example of China's international presence. And first of all, there's the implications for internationalizing China's human rights policy and practice, and the implication that has on human rights protection globally. It also, this study illustrates the lack of clear and enforceable international human rights standards. And if we look at the work of the UN Human Rights Council or even the Universal Periodic Review, we see a lot of aspirational language, but not much in the way of actual concrete enforcement or clear consensus-based standards. So that's another element that's brought out in the book. And then it also exemplifies the rise of authoritarian governance models internationally. So previously, I have discussed with regard to China, the notion of patrimonial sovereignty as describing China's leadership style, which is the patrimonial part is embodied in serve the people language, and the notion of looking after the society in a kind of a patrimonial way, but also the party remains sovereign and largely above the accountability spectrum for the population generally. So you have a situation where the government is responsible for the people, but not necessarily responsible to the people. And that's the patrimonial sovereignty discourse, which I've discussed previously. And in China, the legitimacy of its political leadership is based largely on notions about meritocracy, superiority, the Marxist historical determinism, with an add-on of Confucianist virtue. And one of the things that is worth asking about is the question of reciprocity. So that in the Confucian governance model, virtue was the key to the legitimacy of the regime. And virtue is not simply the mastery of texts, of Confucian texts, but it was also in personal conduct. And it included the notion of reciprocity. So I invite folks to think about that in the context of our leadership situation in China today. So the book is really about China's human rights orthodoxy. And I just want to take a moment to just tell you what I mean by that. And so orthodoxy, human rights orthodoxy, are the basic norms and practices mandated by the ruling regime as a basis for human rights law and practice. So I would contrast orthodoxy with legal doctrine. Legal doctrine it derives not simply from the legitimacy of the source of the doctrine, in Max Weber's terms, the lawgiver, but also from internal consistency of logic, jurisprudence, and practice. On the other hand, orthodoxy, it derives authority almost entirely from the legitimacy of the source of the mandate. So if we think about canonical orthodoxy, it derives authority and claims to obedience from the legitimacy of the religious organization from which it emerges. And China's human rights orthodoxy similarly gains authority from the legitimacy of the ruling regime. And this legitimacy question, as people who've read what I've done in the past will know, is a subject I have great interest in. So there is a discussion in the first chapter of the origins of China's human rights orthodoxy, going back to Confucian authoritarianism and human rights in imperial China, the question of virtue and text technique, the question of relationships or rights. Rights tend to be sort of individually related, and so sometimes challenge a relational orientation of Confucian virtue. In the transition to the Republic of China after 1912, the question is virtue or performance. Is the regime performing its duties as a government and providing prosperity and security and so on? Or is the government's legitimacy still just based on the virtue of its proponents? And that was an ongoing challenge for the Republic of China. And then the PRC, we see a transition from revolutionary transformation to what I refer to as regime-led development as a key theme. Now, in all three of these periods, there is what many refer to as the T-Yung dilemma. In imperial China, when we look at the 1898 Days of Reform, part of that was about acquiring international technology and military might, as well as economic strength, in order to resist the depredations of foreign imperialism. And the idea was to use those foreign technologies, but not allow them to intrude on the the essence of Confucian culture. And in the Republic of China and the indication of the May 4th movement in 1919, a very similar thing was going on where reformers were calling on the government to adapt education provisions, administrative provisions, economic provisions from abroad in order to strengthen the Republic of China, and yet there were others who insisted that the traditional Chinese the traditional Chinese value system needed to be dominant, and so that created a conflict and some obstacles. And I would suggest that after 1978 third plenum and the legal and economic reforms, China has also looked abroad for international legal standards and grappled with them in a very T-Jung way of trying to use international standards, but not allow it to intrude on the basic principles of party-led governance. And I talk about that in one of the early books or early articles, actually, that Dean Fu Hualing mentioned. So when we look at Chinese human rights orthodoxy, I have suggested that it follows a theme of regime-led development. And regime-led development allows China to embrace the internationally recognized right to development as a human right, but also gives the regime great authority to lead China's development process. And the foundations for this orthodoxy are found in the four cardinal principles that we first heard a lot about in 1979 and have heard quite a lot about since. And what we see in the human rights orthodoxy, the first principle or precept, I've said, is the contingency of rights. The contingency of rights. Rights are not absolute. And if we look at the Constitution and we look at the Article 33, for example, Article 33.4, which combines rights with obligations. And if we look at Article 51, which suggests that requires that people uphold their duties as well as in the course of enforcing rights and not harming the interests of the collective and so on. So rights in the Chinese human rights orthodoxy are contingent and not absolute. And this follows the cardinal principle of the socialist road, because the socialist road is really about this transition from feudalism to capitalism to socialism to communism. And that process is really about class, and rights are determined by that sort of class status. So the socialist road and the contingency of rights are intimately linked in the way that I've been thinking about it. A second element is first of the four cardinal principles is the socialist road. Second is the people's democratic dictatorship. And this, I would say, equates to a human rights orthodoxy precept of stability for development. In other words, the theme of stability pervades much of China's human rights discourse. And our colleague, Sarah Bidoff, for example, has written extensively on this, and it's a very important component of China's human rights practice. And so that is linked very clearly to people's democratic dictatorship, where the stability and control is necessary to ensure China's development. Thirdly, the third of the four cardinal principles is party leadership, of supremacy of the Communist Party of China. And we see this repeatedly in China's human rights orthodoxy by reference to the Sangha Zhishang, the three supremes, and also the establishment and reestablishment of CPC Dangzu in many, many units across the government and in the private sector. So those three components are what I call the precepts underlying the principle of regime-led development, the precepts being the contingency of rights linked to the socialist road, the precept of stability for development linked to the people's democratic dictatorship, and the precept of party supremacy linked to the cardinal principle of party leadership. Now, the additional cardinal principle has to do with the language or the identity of leaders. So originally it was Mao Zedong thought, Marxism, Leninism, Mao Zedong thought, and then Deng Xiaoping thought came, and every leader since then has had an element added to that cardinal principle, but I will not go into detail on that at the moment. So one of the questions about human rights and the focus of this book, which is China's activism internationally, is why does China care about international human rights standards? They have a strong country, they have a powerful country, they have a wealthy country, relatively speaking, and there is many people concerned about human rights in China, absolutely, but it is, I think it's fair to say, not at the top of, many people would say it's interesting that it gets so much attention from the regime. And one of the things I try to do is to explain that in this book. And part of it is, a big part of it is the legitimacy dilemma. The legitimacy dilemma, which again, I talked about as early as that Riding the Tiger article 30 years ago. So if we think of Max Weber and Max Weber's work on legitimacy, he refers to typologies of traditional charismatic and rational legal. And if you apply those to China, there are some difficulties with it in the sense that if we think about traditional, yes, we see a lot of reference to traditional Confucianism and a lot of reference to traditional Chinese values and so on. But at the same time, there's not much agreement on what the tradition actually is. And this is particularly regarding the question of CPC history. So whether we talk about the late 50s or the 60s or later, there is disagreement on a lot of elements of CPC history, even to the point where there is now restrictions on how it can be dealt with and so on. So there's an issue there about the traditional legitimacy. The best, or maybe one example is the kindergarten song or the preschool song. Without the CPC, there would be no new China. 没有共产党 就没有新中国. So that's an example of this traditional legitimacy approach. Now, on the charismatic side, President Xi Jinping has certainly attempted to, or has succeeded in expressing that the legitimacy of the regime is strengthened because of President Xi's personal attributes, dedication to his job, commitment to China, and so on. So there's a charismatic element there. But at the same time, there are questions about whether that can be institutionalized. And actually, we're finding about that right now in the context of the common prosperity discourse on the economy. And then finally, when we look at rational legal, that brings in all of the issues about the socialist legal system and whether it's formalistic and instrumentalist or whether it's universal and so on. And I leave that to people smarter than me to talk about that, but that's also an issue. So those three Weberian foundations for legitimacy, traditional, charismatic, rational, legal, there's a certain level of tension in their application to China. So ultimately what we have is we have performance legitimacy, the legitimacy of the regime based on its performance. And this is where human rights play such an important role, because human rights are present in basically the totality of political, socioeconomic, and cultural relations. Whether we look at labor, whether we look at the environment, whether we look at standards of living, whether we look at culture, and then go into the political, civil, and social, economic, and cultural rights, human rights are present throughout life. And so compliance with international human rights standards is an affirmation of the regime's performance legitimacy. And so, but when we get into then that brings us to the T-Yung dilemma, which is how much of those international human rights standards are going to be used and how much of the abiding basic principles of the regime are going to be retained. And this T-Yung dilemma applies directly to the law human rights issue. And part of the focus of the book is to suggest that the international human rights standards, as they are presently, create significant challenges for the regime domestically. And so as opposed to trying to massage them to meet the T of local authority, there's an effort to now change the standards themselves. In other words, to change the standards that are the basis for Yung in the T-Yung dilemma. And the approach to that is disseminating China standards. And that is what the exporting of virtue is about. So that sort of summarizes the kind of a conceptual approach to the project. And then it goes into a number of conceptual examples. And I'll just touch on those, the first one in a little more detail and the others a little more briefly. The first is China and the human rights system. And what I describe or discuss in the book is, first of all, there are key perspectives that China has brought to its engagement with international law. Sovereignty is certainly top of mind, territorial integrity, as folks in Hong Kong well know, non-interference, non-aggression, peaceful settlement of disputes. That was re-articulated during the Kosovo crisis and the embassy and so on. And then, of course, national equality among states, and that is part of the global governance reform. So China brings those perspectives to its engagement with the international system. Now, the international system has a number of international human rights standards that China has either ratified or signed. And under the Vienna Convention on the Law of Treaties, a party that has signed a treaty cannot take steps that would impede its realization pending ratification. So signing still contains or brings with it quite a lot of important obligations. But if we look at the Universal Declaration of Human Rights, the International Covenant on Civil Political, the International Covenant on Economic, Social, and Cultural, we look at the Bangkok and Vienna declarations in 1993, We see China's participation in the CEDAW Convention on Discrimination Against Women, the CERD Convention on Elimination of Racial Discrimination, the Paris Convention on Climate Change, and so on. So China has signed on to a whole raft of international standards. And it's important to recognize that when we look at the Vienna Declaration from 1993, it suggests that all human rights are universal, indivisible, and interdependent and interrelated. And that's a standard that is that China purports to adhere to in its compliance or its performance of international human rights standards. So what I suggest is that there has been a set of phases of China's engagement with human rights. So initially, political reform in China was talked about in terms of democracy. It was seen as the fifth modernization. But after the Tiananmen disaster, democracy became untenable as kind of a theme for political reform, and human rights became more important and more accepted. And I would say that in those early years, there has been what I kind of refer to as tentative acceptance by China of the international standards, of ritual participation, in other words, participating in lots of meetings, and nominal equivalence between international standards and China's conditions. And so if we look at the white papers on human rights from 2005 or 2010, for example, they place a lot of attention on participation. And they also talk about in the 2010 white paper, a long discussion of the rights that are conferred on people in the PRC. And that is what I refer to as an example of nominal equivalence. Then I see a second dimension of this, and these are not sequential processes. These are really kind of layered, and I think I use the term layered in the book. They're interrelated, but there's some chronological difference, but I prefer to think them as layered. And on the first layer being tentative acceptance, and the second is emerging resistance. So what we see, really beginning with that 2010 white paper that I suggested, and also with a human rights action plan that began in 2009, we see an effort to promote graduated compliance and local interpretation. And the question of graduated compliance suggests China respects the international standards, but as a developing country needs time to comply with them. This is not quite the progressive realization discourse of international human rights law, in that progressive realization requires best efforts. And that's not as evident in the gradual compliance discourse that we've seen in Chinese documents. And in terms of local interpretation, the question is localizing the performance of international standards, that's localized performance, but also local interpretation of those very standards. And that's a beginning of this emergent resistance, which leads in turn to the current period of activism in actually challenging international standards. And this is where China is disseminating its human rights orthodoxy in a way that is akin, in my estimation, to exporting virtue. And there have been a number of places where China has done this, the UN Human Rights Council, for example, and the question of membership, the question of localization of voting, the question of respect for human rights rather than enforcing human rights. We also have seen efforts by the government to talk about a shared future of mankind. And a shared future is not quite the same as universality, mutuality, and reciprocity that are embedded in international human rights standards. It's a recognition of shared interests, but it's not necessarily an action plan for how to carry out those things. There's also a lot of attention paid to development. And if we look at China's white papers on the right to development in 2016 and its human rights white papers in 2017 and 2019, we see quite a lot of attention paid to limits on human rights born out of conflicts with the right to development. And that's why it's so important to think of the right to development as a human right, which is, I think, consistent with much of the discourse, because in China's estimation, some human rights take precedent over others. And if you have that view, which seems to contradict the Vienna Convention, but the Vienna Declaration, rather, 1993, but nonetheless, if you are of that view, and many states are, then if the right to development is a right, other human rights can be subordinate to that right. And we've seen that a lot in China's discussion about development. And finally, localization. In China's Universal Periodic Review statements in 2018, there is discussion about human rights with Chinese characteristics. We've also seen what I refer to as a rectification of names approach of localization of ideas about democracy, CPC rather led democracy, filtered democracy, and also the rule of law, CPC led, and from Fajr, the legal system, to Fajr as governance through law. So we've seen a bit of reimagining of these fundamental, what Kelsen would call Grundnorms in democracy and rule of law, which of course are foundational for human rights discourse, which China is also working on. So that summarizes sort of its international engagement. And then I do 3 different case studies, one on political expression, which we can talk about, and it's in the book, and I won't, given the time, go into it in great detail, except to say that political expression has been required to suit a number of the regime's priorities in terms of party leadership and security. And I go into that in some detail. And then I also talk about the international human rights, or China's insertion of its human rights standards into international economic relations. And the 2 examples I give in particular are the Belt and Road Initiative, where it specifically does not address human rights issues, and the Asia Infrastructure Investment Bank, which is very specific about that, about the bank not engaging in discussion about political arrangements with local governments. And then also in the China-Canada bilateral relationship, which I also talk about in some detail, there is a very limited, I would say, acceptance of the role of human rights in those things. Then the chapter after that talks about the question of China's human rights standards as they apply to international labor standards under the WTO and international environmental standards under the ILO and the international environmental standards under the Paris Agreement and the UN Environmental Program. So those are examples where I explain how China's human rights standards are being inserted into those. And I'd be happy to talk about them in greater detail, but I'm a little conscious of the time. So I will leave it with the main focus being on the conceptual framework for the book and its application to these case studies of political expression, international economic relations, and labor environment. Thank you.
Thank you so much for taking us through the book, and I think all want to read this book to know a bit the chapters and the case studies, and also the centrality of this Qiyong debate throughout the modern Chinese history. Started in the Qing dynasty, we haven't really solved that dilemma. So that is always a fascinating area for us to do further research. So let me pass the floor to my colleague, Jack, to give his comments.
Okay. Great. Thank you for the privilege of commenting on this book. As I mentioned, before we got together talking, I've been reading Professor Botter's work for the entirety of my academic career, and so it's quite a pleasure to comment on the book at this stage. I think one of before I get into my own questions, the virtue of the book, right, especially in the context of current scholarship, is that it highlights, in one way, the connection between domestic challenges and international promotion or engagement with human rights, which I think is increasingly a trend in the literature, and how nations sort of coordinate their sort of domestic and international view of human rights, right? And this something that's become almost as universal as constitutionalism. And I think the book, in a variety of areas, clearly documents the shifts in the assertiveness that China has taken in international bodies and various contexts in promoting its particular view. So in light of that, I had to start with like 2 methodological questions. And one is what Hualing was just talking about, and the use of these Confucian concepts. And I wonder, given the idea and sort of the debates over the use of Confucianism by the contemporary regime. I mean, in the book, you cite Lionel Jensen, and Jensen's contributions largely is to point out how many different ways Confucianism has been interpreted by foreign and domestic audiences over time, and whether or not using concepts like Qiyong from like the the 19th century obscure the fact that these are common issues that China has with other places, right? This isn't the Song dynasty. We're not debating whether or not, Neo-Confucianism is real Confucianism in a truly domestic context. This is in a context where the party is trying to use Confucianism as a source of legitimacy, and placing the analysis in those terms would seem to sort of reinforce some of this historical revivalism that you critique and sort of point to this sort of exceptionalism that China treats. So that's I wonder about the continued usefulness of these Confucian concepts and analyzing what's actually going on in the contemporary. The second thing is given the idea that China is trying to export a particular orthodoxy, is how would we measure the success of this export, right? So in law and development studies more broadly and in other fields, this idea of how nations sort of influence other nations is a long and recurrent sort of methodological challenge. And so I wonder about the utility in that of sort of the formal statements and treaties that make up a lot of the analysis, right? There's a lot of evidence of this assertiveness, but of practice, right? So like one of the quotes that jumped out of me is the tentative acceptance, right, in China of international human rights after Tiananmen Square. And I really wonder, was there a tentative acceptance, right? Or was this purely something that reflected a rhetorical rather than an empirical practice? And there's a huge literature, right, that questions the impact of human rights treaties in general. And so I wonder sort of how that sort of fits into this analysis. So when we're going through the different case studies like labor and the environment, I was really wondering whether there were places we could point to where there was a good human rights practice, and then China came in and sort of engaged in the practices that you lay out, and now it's bad, right? Can we actually have one of those sort of causal stories? And part of the reason why I asked that is it seems we're in a moment right now where all the evidence we have is that these attempts haven't really been working very well, right, at the practical level. When they shift from rhetoric, even in the BRI context, you get a lot of backlash, right? Especially in the freedom of expression, the engagement with overseas universities, Confucius Institutes, et cetera. It doesn't seem that there's a lot of evidence of the impact. And so those questions lead me to sort of the bulk of my reaction is in reading through this, you talk about how capacious human rights are, and they touch on these different subjects. And I think this gets into these debates about whether or not human rights as a frame is the most useful for understanding what's going on, right? It's hard to argue with how the book documents these sort of descriptively accurate changes in treaty language and terminology that China's been able to achieve. But at each moment, there was these sort of like pauses that I have when sort of if human rights is sort of getting at what we're trying to look at. So one thing was, you talk about the lack of an international human rights sort of agreement, and that's how do we measure or strengthen the existing orthodoxy, right? So if we think of a country like Canada that's used human rights and acknowledged those treaties in its sort of constitutional adjudication and even in law reform, and then we compare that to the US, the type of exceptionalism that you point out in the Chinese context about sort of the limitation on human rights where PRC interests permit. I mean, a lot of those things could be applied to the US, right? The idea that the US could be subject to any international human rights critique, the relationship to the ICJ, the ICC, or even the WTO. It seems in that sense that it's hard to know whether that's really describing the same type of dynamics. We want to sort of lump it into sort of China and the international system, or is this really talking about China in particular styles, a variety of styles? And I think a lot of recent discussion about human rights really gets at this debate about whether or not economic globalization or global political economy, as you refer to it, has ever really been pro-democratic or pro-human rights, right? I mean, one of the alternatives tellings is that instead of sort of tentative acceptance at different times, there was sort of a learning process about how human rights discourse actually works, right? And the cost of these sort of violations. So you mentioned the Washington Consensus, but the Washington Consensus had no particular democratic components, right? It was the 10 points were all about economic policy. And this sort of plays into these very large debates, that Sam Moyn has popularized recently about the relationship of human rights and the limitations of that frame and neoliberalism, right? Why China can do this is because the human rights frame is adaptable and has never really sort of committed any country to sort of really restrain its own self-interest. And so this also then plays into these debates, and I sort of feel your confidence a little bit in the book about some of the tenets of the power of trade or the power of engagement. And so I'd be curious if you still feel sort of that whether that type of modernization theory, right? You mentioned Michael Sander's book and Alex Sykes's work, this idea that trade and engagement can promote human rights, or that more wealth and information can like create these democratic pressures. But we seem to be in an era of great doubt about those types of precepts. And I think throughout the book, this comes up in the question about, you talk about the governance ideals that particular countries like the US or Japan has. And I keep sort of wondering about the practical effects, right? So in comparing what China might do in the BRI, this is sort of these debates about China and Africa. You mentioned the China International Commercial Court. You think about that in other international commercial courts, and whether or not the rhetorical and the practical differences are all that different. Right. So if we take the AIIB and compare it to the World Bank, right, is, you know, the type of governance ideals that's potentially articulated in their sort of lending agreements really lead to those types of practical effects? Because a lot of times when we think about this, the evidence beyond a change in rhetoric is sort of difficult, like engagement with, you know, like a military junta in Myanmar. Well, there's lots of countries that engage with authoritarian and military regimes, right? Disregard for environmentalism. It's a little bit hard to sort of pin that down to something that's been done well, right, in other contexts, and that China is undermining. And as someone who works on labor, I think that's where this sort of is most striking. I think there's a particular part where you talk about the assumptions in GATT and W trade regime that production costs are determined by a free market as adjusted through independent labor unions and collective bargaining. It's really hard, especially as an American, to think that that's really like the ideal that's being sort of contrasted to China's sort of like orthodoxy, right? We've had a secular decline in labor rights over the 20th century. The World Bank, right, for a long time was openly hostile to employment rates, right? They had an index that adjusted loans based upon that. And then, you know, regimes that are described in the book as sort of liberal, you know, democracies that might, you know, have sort of more labor values in them. India and Brazil have both recently engaged in massive labor market deregulations. And there's some question about whether or not they are in fact liberal regimes. So this idea that like there seems to be a lot going on, but whether or not human rights and the sort of China versus the international system really sort of captures some of these dynamics seems to sort of be an open question in my mind. And then the last bit about the international response, right? So in the conclusion, especially, you lay out sort of like 10 plans to try to help shape, you know, we can't sort of force changes on Chinese policy, but we can shape their perspective on what in fact is their national interest. So I noted in these 10 suggestions, 3 use the word invite, 4 use the word encourage, 1 uses the word investigate, 1 monitor, and then 1 has sanctions. And in the Hong Kong context, I'm thinking like, isn't Hong Kong administration like all of those things, even probably more systemic sanctions and trade actions have been attempted without any sort of demonstrable impact. In fact, maybe some countervailing impact in those areas. And so part of this, the idea of like, what's the actual nature of the global political economy is like, wouldn't a true commitment look something a little bit more dramatic, right? So if we've had this secular decline in labor rights, you know, there's all these things where, you know, if we have FDI in another country, you know, what is that country going to force that economic production to look like in the context of labor rights? We could do things, or any country could do things like mandate co-determination, unionization, or certain broads anytime, right, one of its companies operates abroad, right? You know, when it comes to engagement with authoritarianism, we could have very different rules about legal ethics rules, about representation of authoritarian or human rights sanctioned entities, which we don't have. So it seems like there's a lot of areas where we could actually demand that our economic interface has an inherently democratic structure and sort of live up to our own ideals as something that would really sort of generate force in these types of engagements, where it's not just a negotiation over a trade table, but sort of an issue of structure that may be a more effective deterrent than all of the different things that have been tried up to date, especially in the Hong Kong context, that don't seem to have achieved the deterrent effect that we might otherwise want. So I think obviously there's a lot of questions, but I think I'll leave my comments there.
Okay, thank you, Jack. Before I invite Ian to make her comments, may I invite the audience to input your questions into the Q&A chat room if you have any question. Pitman, do you want to have a quick response to what Jack said?
That'd be helpful, because then I can get to everything and keep them.
Yeah, there's a lot of things that there. So yes,
great comment. So thanks very much for that. So one of the one of the themes of this book does have to do with legitimacy, and in other work, I have not. There is this question of performance legitimacy, but there is a very powerful practice of formalism in depicting performance, and so official depictions tend to be more powerful and more often used as ways of gaining legitimacy and authority than actual performance issues are. And part of that is the dominance of formalism in the Chinese legal system. So that's one of the reasons why I do tend to look at official statements, because part of that tells you a lot about what the regime is focusing on. But I completely agree that there's no way to, and much use in fine tuning all the different schools of Confucianism between whenever ago and now. So I think that's true. But I do think the Tiyung dilemma is still a useful way to think about China's engagement with the world. Frankly, I recall from the Peng Jun book I did some years ago that two of Peng Jun's early quotes right after his rehabilitation was that in developing the legal system in China, the past should serve the present and the foreign should serve the local. And that's that's another variety on Tiyung, although it's applied not only internationally, but also domestically. So I do think there is this question of learning the lessons from abroad and from history. But the question is, when they lead to conclusions which are too challenging to a dominant orthodoxy, that's where the tension is. And I think that's still useful. In terms of measuring success, so, I've wrestled with this question quite a lot, and I have a little file that I keep for post-copy edit news items on all the things that are in this book, because, you never know when you're going to do something else about them and so on. So you're quite right that the question of measuring success. But here again is where I have observed in the past that the Chinese regime, not simply the current regime, many regimes in the PRC, rely on formal kind of historical documentation and expression as testament to their performance. It's formalism. And we see yet again another attempt to revise the verdict on Chinese history, for example, just recently. So I think there is an emphasis on that in the PRC legitimation dynamic. The reference to performance legitimacy, which has been a way of getting out of that formalistic element, but performance legitimacy is fine, except that if the response to it is formalized depictions of achievements, then is that really performance or not? But that is part of the structure of building legitimacy as I can observe it. And so I think it's worth paying attention to. But however, it is absolutely, the point you're raising is really, really important. And I think I think I admit this in the conclusion, it's just too early to tell what the impacts are going to be. But when we do look at the changing process in the UN Human Rights Council, for example, and the Universal Periodic Review, we see that China has absolutely had an influence on their behavior. On the political expression and controls on political expression, obviously we've seen lots of that in lots of different places, and there's a new report out every time I turn around and so on. But again, part of that, and the question is about building an historical record. If anybody can say whatever they want, it goes into the New York Times, that's creating a historical record that is out of China's control. So China has worked very hard internationally to dominate that, or at least to control that process. And I would say that in Canada, for example, they've been quite successful. And I think we've seen that success repeated elsewhere, where a Chinese policy position, whether it be on domestic minorities or environmental conditions or climate change, what have you, gets incorporated into a domestic debate about the issue without much critical scrutiny, just because China is big and important and powerful. So I do think that there is a process by which expression is being influenced by these Chinese efforts, but it is very early to try to tell about that. Now, when we talk about the question of tentative acceptance and the impact of treaties and so on and so forth, again, I really never thought I'd say this, but this is an area where a kind of a doctrinal, or in my example, an orthodoxy analysis is actually helpful. I, for almost my entire career, talked more about practice and did lots of interviews and, on-site questionnaires and all that sort of thing, trying to find out what was really going on as opposed to what was in the statute books. And I wrote extensively on the problems of formalism and instrumentalism and Chinese legal governance and so on and so forth. But in this particular instance, because the human rights orthodoxy is formalistic and very much at variance with what many people perceive as human rights conditions in China, that needs to be explained. And part of the explanation for it is that orthodoxy is about principles. And those principles are about building an historical record that undergirds authority and legitimacy for the regime. So it is a formalistic take. It's a doctrinal take. And as I said, I've not always thought that I was just purely doctrinal, but nonetheless, and there's a use for that given the formalism that pervades Chinese governance. Okay, on a few of the other points, the U.S., the parallel to the U.S. and so on. And one of the things that's interesting here is that if we look at the AIIB, and I mentioned this in the section, where there's a specific provision that says that the bank will not essentially intrude on political decision-making by client states. Well, that is taken virtually word for word out of the World Bank executing agreements. So almost word for word. But there is a major difference between a World Bank saying to developing economies in the world and to itself about that in a context where most of those developing countries are authoritarian regimes that have abysmal human rights records. The bank will lend money and not push our liberal goals on our clients. So that's what's happening with the World Bank. But with the AIIB, essentially, China is giving license to all of those authoritarian clients. So it is a slight difference in terms of the way that the same text in the World Bank document and the AIIB has very different implications for local human rights conditions. Okay, the international political economy issue and whether it's ever been pro-democratic. I mean, yes, I think there's a lot of evidence for that. But again, this book is really about ideals. It's about an orthodoxy. And so, yes, I think there's a lot of evidence to suggest that that what you're saying is absolutely right. But when we talk about reliance on themes and ideals, that is a legitimacy building exercise, which allows us to focus on that instead. And I agree this other issue is critically important, though. The BRI, the rhetorical and or practical differences in terms of human rights and so on. There's been a lot of variation, and actually, I've tried to capture some of that in the section there, where there are plenty of defenders of China's behavior in BRI and plenty of critics. But in all of those instances, local human rights conditions are a big part of that, and they're not actually part of the Chinese BRI approach. And I give a bunch of documents on BRI that actually show that. And I think it's, but it is a question of rhetorical and practical differences. And I think they're there in the rhetorical part, but because this book focuses on that as a matter of ideals and orthodoxy, I focused on that as well. And similarly with the ideals on employment and labor. So I think those are critically important points, and the practical operational reality of all this is just critical, but I do think it's a little early to tell. And so we have to start with its exercise in legitimation building, and that's based on essentially formal documentation and a bit of formalism and legal interpretation. In terms of the international responses, being more, I'm sure we can be more insistent. And you're quite right that we should be more insistent. I am kind of struck, just as you were mentioning that, by the comments of the director of the UN Development Program that was in the paper just today, actually, where he basically said what the director of the WHO has said on China's COVID response, which is that we are only in these countries by their invitation. And so that is, on the one hand, an explanation for why they don't insist on different kinds of conditions. But at the same time, the UNDP person said, signing up with us is also about signing on to our values. So I actually, I'm sorry, because I think I actually talk about this T. Jung working in reverse. And here where the UNDP head is saying, we work with client states like China, but we have to, we're preserving our own values, but we have to account for the reality on the ground in the areas we're trying to work on. So it's a weird kind of, obverse, if you will, of the standard T-Jung relationship. But in any event, that is the dilemma. And I'm doing a paper for the East-West Center now, and it's from this book I'm writing and so on. And part of the question on COVID or climate change is China is just absolutely essential to all of these things. And so sometimes, and it's, we've all been in negotiations with people we don't like, but they are so important that we have to get them included. And my view has been that by including, by encouraging, by inviting, and having China be more a participant, long-term change is more possible than it is if we are stricter and therefore drive them away. Now, I am perfectly happy to be taken to task for that because I realize it sounds a bit accommodationist, and that's a view that I don't really like. But at the same time, it's important to balance what we're trying to achieve, which is improved conditions, whether it's human rights or COVID or climate change, and China's participation. And, it's not that different from the T-Jung problem. So the more you're Jung, the more the T is threatened. If the T is threatened too much, it's going to resist the Jung. And so that's part of the dilemma. So I've been, but I have to say, in all fairness, that my draft that called for Magnitsky sanctions was done way before it made the headlines. I mean, I was very impressed by the Magnitsky story and the legislation in Canada, but also in the United States on Magnitsky sanctions. And so I put that in actually in a very early draft stage. So it is what it is, and I think it's important. So thanks for those questions. Really great. I wish we had a couple hours to talk about them in more detail.
Yes, we will have the opportunity still to invite you over or go there to visit you to have a longer session to discuss those fascinating and important matters.
Sorry.
So now may I invite Ying to give her brief comments on the book?
Hi, thank you. And Professor Potter, I apologize for coming in late. I'm not sure if my comments have already been covered and to what extent they've been covered in previous discussions, but I just quickly throw them out. First, thank you for accepting our invitation, for being here. I enjoyed reading your book a lot, and it's very relevant to my own interest in studying the legal and social implications for China's overseas investment and development cooperation with so-called BRI countries in the developing world. And my two general comments or questions are related to, first is about the dichotomy between positive and negative human rights that you've laid out in the book. Of course, there has been a dichotomy in the human rights regime for a long time. And what China has been doing both domestically and internationally has been to reinforce and reshape the dichotomy, both in terms of practice and also theorization through those international human rights institutions, such as the Security Council, etc. My question is, from my own experience in my encounter with the policymakers and the normal citizens in the BRI countries, especially in Africa, it seems that there has been an increasing number of interested parties, so to speak, both within the government and generally societal actors in those countries, that there has been an increasing popularity of China's claims for sort of refocusing human rights towards development-related rights rather than an emphasis on political civil rights, which is more of the claim from the Washington Consensus or the new Western neoliberal democracies. So, and of course, there's far from a consensus from the audience in those BRI countries, of course. My question is, I wonder if you could, based on your experience and the surveys and your interviews, could you elaborate on how this China's claims or argumentation about reshaping our understanding of human rights in terms of the dichotomous distinction between positive and human rights, and how are they received by different audiences, especially considering the variety of preferences of the audience from the developing countries and those in developed countries? That's the first comment. And secondly, it's related to the comments made by Jet earlier. It's about the conclusion part of your book, in which you mentioned several proposals for change. I think most of the ideas seem very noble to me, and they touch upon the very basic issues of human rights concerns in China. But my question is more about what mechanisms do you think can be employed by those either scholars or policymakers from other parts of the world to engage China? So, for instance, do you see the UN or a World Bank or perhaps a regional organization like the African Union or ASEAN be a viable option for making such a suggestion or exerting pressure on China? Or more specifically, in the trade regime, do you see if there any difference between the pursuit of such proposals through a WTO or through regional arrangements like TPP? I want if you could elaborate on those sort of venues through which those reforms or changes could take place. Thank you.
Thank you very much. Terrific. Okay, so in terms of the dichotomy between positive and negative rights, positive rights tend to be associated with development regimes because they are usually moving countries from poverty. And so they are guaranteeing various conditions in terms of housing and education, social benefits, and less concerned with the state being insulated, the society being insulated against state intrusion. So I think when we look at the positive and negative rights discussion, they do tend to align with the difference between liberal and more authoritarian governance, but not perfectly, obviously. And the thing that I try to make the point about, which is that the positive and negative rights dichotomy is very rough-hewn, to put it politely. And there are many human rights issues today in terms of disadvantaged persons, in terms of telecommunications, in terms of health and so on, that just do not fit neatly into that particular dichotomy. But I put that in there as more as context. And I think it's fair to say that China's efforts are intended to and are having an effect in shifting attention to the more positive rights. And we even see this in liberal democracies. I mean, much of the debate in the United States, for example, over the current budget debates or in the EU is really about, yes, we're glad we have legal processes to protect ourselves and so on and so forth, but how am I going to get a job? And how am I going to make a living wage and so on and so forth? So that attention to the positive dimension is not limited to developing countries by any means. So now, in terms of the BRI, I think one of the perhaps a way of comparing BRI with, say, the Marshall Plan or other liberal-driven things is that China's BRI is actually reinforcing local preferences for development-oriented, authoritarian, positive rights regimes, whereas in sort of Western European or Canadian development policies, it's really trying to persuade audiences that have that preference to think about things in a different way in terms of protecting individual rights. So I do think you're quite right that the parties in the BRI, many BRI client states are very enthusiastic about China's standards, but that's not to say that labor organizers and ordinary working people and families who are suffering from environmental degradation and so on are as enthusiastic. But I think the question of how it's received by different audiences, I think in BRI, a lot of that is just performance. People are just going to see that they have jobs where they didn't used to have jobs, or they have better incomes and so on. So I think there's where the performance legitimacy dimension is going to be critical. Now, in terms of the proposals, of course, the mechanisms are important. And I gave a few hints on possibilities of mechanisms for carrying some of these things out. But I guess I would second the notion here. The dilemma is this: multilateralism is better than unilateralism and bilateralism. And I think everybody agrees. But the difficulty, as we have seen for these many years, is that multilateralism is unwieldy and very difficult. So there's a combination of multilateral and sort of, I think way to say plurilateral, where you have regional organizations and ASEAN is one example, but there are plenty of others where you would have potential regional consensus about the issue and how to engage China on it. Whereas where we're looking at multilateral organizations as a whole, like the UN, for example, the difficulty, as I mentioned, in the UN Human Rights Council is the election of seats now being up to the General Assembly as opposed to regionally specific electoral groups, and that has increased China's influence. So I think the question of how do we do this, but part of it is, again, part of it is who's our audience, and I like to think of an audience as international, but governments need to internalize the importance of those 10 suggestions that I made. And I think that's the first step. And national governments and other opinion shapers, universities, NGOs, et cetera, they need to internalize the importance of those and then start working out the mechanisms for enforcement. Because I think the proposals themselves, when it gets to persuading a government foreign minister, for example, or assistant deputy minister for foreign affairs, that that these things should be done, there are many, many countervailing influences that tend to lead to them being watered down, even though they may seem a bit tame at the moment. But anyway, that's a terrific question and always a matter of great importance.
Thank you. Thank you very much.